law matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program's been created to educate, inform, and help you with the law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We provide information and resources to help you decide whether or not you might want to handle some issues yourself. Perhaps you'll need to contact a lawyer. In either case, our hope is that you will be better prepared, and so will the professionals who you decide to consult with. The idea is that you'll save time and money, hopefully achieve better results. So we want to welcome and thank once again Bazar and Associates,
Thank you.
law firm in East Providence, who continue to offer their insights and their information. And today we're going to be talking about the jury system, the jury service. Jury service is supposed to be a way for U.S. citizens to participate in the overall process. It's considered, jury duty is considered to be a privilege. It's considered to be a vital civic responsibility for all eligible citizens in this country. So we thought it would be a good idea to discuss, how does that work? How are juries selected, grand and petite? What are the differences? What do they do? Also, we'll be talking about from the jury pool to the box. How does that happen? And who qualifies? And what are the exemptions? And what are some of the scams? And even if you should need to, how do you get excused? So, David, let's start with what the jury system is set up like in our country.
Sure. So the right to a trial by jury is sort of a cornerstone of the American legal system. And it's a right in every criminal trial and in some civil cases. The common law, which our law is based on from England, there were certain cases in equity tried to judges where there was not a right to a jury trial, claims for injunctive relief, those types of things, where the order is not for a monetary amount, but rather to stop somebody from doing something. That's an injunction. That's what an injunction is. And those don't have a right to a jury trial. But most other civil cases where there's a claim for money, there's a right to a jury trial, and certainly in criminal cases. So that's the cornerstone, and that's why they say that jury service is such an important role in democracy and in American civil jurisprudence. So that's why people really mostly honor their duty to do that, although many times you'll hear, how can I get out of that?
Yeah, so we should discuss how that actually happens. But first, there are different kinds of juries. There's a petite jury. What is that versus a grand jury? And who gets to serve?
So the petite jury is what most people think about when they think about jury service and jury trials. The petite jury is the jury that sits at the trial level. And when you're called to jury service, it's usually for that jury pool that gets selected for trials. So what happens is in a civil trial, generally, in Rhode Island, usually 8 people get called to sit on that jury, where 2 of them are alternates and 6 will eventually decide the case. In a criminal case, it would be 14, where 2 again are alternates and 12 would decide the case. So the jury that's called to service for that type of case, a petite jury, is called to Kent County in Providence, in Rhode Island, or Washington County, Newport County, Providence County. And if it's Providence or Kent County, generally speaking, you're given notice to show up to court, and you have to show for at least 2 days. And if you don't get on a jury within those 2 days, then that's the end of your obligation. If you do get on a jury, you have to stay until the end of the trial. Washington County, Newport County, it's come for 1 day. If you get on a jury, you have to stay. If you don't get on a jury, then your service is done.
How does the jury selection process begin? How do they get the universe? What's the pool?
Okay, so now we're still with petite juries, and that's what we might commonly call trial juries. So what happens is a number of people across the state get notice to show up for their jury duty, and they're ordered to report. So they go to the jury assembly room. A judge swears them in as potential jurors, gives them their oath as a juror, explains to them the process. There's a handbook on the Rhode Island Judiciary website that anyone could download, as well as a video. And the rights and obligations of the juror are explained, and also some explanation of what to expect at a jury trial. So in a typical jury trial, what would happen is a select number of those people who have reported are sent as the jury pool to the trial room. And then the judge will sit and explain to them, although there's one judge who likes to stand when she explained, and she's very good at it, what the case is about, who the parties are, and just a little bit of a flavor of what's involved to really ferret out at the beginning any potential conflicts. Then there's a drum with ping pong balls, so to speak, that the jurors' numbers on them, and they pull out the juror numbers as they go through the process to sit the potential jury in the box. And so the next process is called voir dire, where the lawyers go through and ask questions, or the judge may ask some questions of each jury, so that the two sides get a chance to vet the potential juror and whether there might be any issues or biases of that particular person.
And when this starts, David, I understand that it's registered voters. There, in some states, and I hear that I read that it differs. Some have to have driver's license, or you might be pulled from a driver's license list. So it is meant to be random, correct?
Correct.
Because some get pulled 3 and 4 times, even if they haven't served. Others may never be selected or never be pulled.
So we'll go back to the selection of the jury after, and I'll go to how do you get on that jury pool and where do you get pulled from first. So there are a number of different places that the court can pull jurors from. Registered voters is an area where you can get pulled from. If you have a valid Rhode Island driver's license or Rhode Island identification card, you can get pulled from that. I believe there's a couple of other places too that might be sources for potential jurors.
Same is true in Massachusetts or not?
My understanding is,
Okay.
Certainly the registered voter list, I believe, is an area where they pull from. And so those are the people who are eligible to be on juries, because you have to be over 18, so to register to vote, you have to be over 18. Driver's license would have to also require that you be over 18 to get pulled from that. So the eligibility to serve is registered voter, driver's license, those types of things, and live in the state and be over 18.
I understand you're going to go into a few more details about the fact that not all who are called actually serve, but others who aren't qualified, those who are serving as police and fire officers and their fire officials, if they're on duty, are there some others who are exempt from certain kinds of trials?
Yes, government officials, I believe, are exempt. Elected officers could be exempt, although I remember one time Governor Sunland, I think at the time, was served notice to serve as a juror, and he showed up, and I think he actually got picked for a trial.
Did he really?
My recollection. But he would have also had another exemption because he was a lawyer, and lawyers are exempt.
Why?
Well, really, I think one of the reasons is because there would be a bias potentially for the other jurors to rely on the lawyer to give advice, and maybe that lawyer might have more influence over the jury room than the other folks, which could be a concern. But it's an exemption for the lawyer to exercise, so if I were called, I would actually not exercise that, and probably would never get on a jury for that reason, but that would be up to the lawyers who are picking the jury to decide.
And you were starting to explain a little bit about voir dire, which is, French is to see, to say, but actually it means to discover the truth.
Right.
And how does that process actually happen?
So depending on the type of case, it can be a long process or a fairly quick process. There are people who make money as jury consultants to tell the attorneys that hire them what is the best potential juror for your case, who would be most sympathetic to your side of the case, what type of person might you want to stay away from. So it can become very scientific. Now, one of our famous trials that you may remember, O.J. Simpson, I think may have taken a very long time to sit that jury pool for a number of reasons. First of all, there was wide notoriety and publicity about
Sure.
that case before it came to trial. So you tried to sift through the pool to find those who have been least affected by that, which can be difficult. When we had the station fire here, we had jury information sent out to the potential pool for a survey or questionnaire for them to fill out well in advance of trying to set the case down for trial, so that the lawyers would have the ability to go through in advance and see a lot of, and the judge too, what a lot of the potential problems could be.
Let me interrupt you about that for a moment, because when it comes to you're wanting to have someone with an open mind, does that necessarily preclude the fact that, as with the case of the station fire or even OJ, people have read the news, they've heard the news, that wouldn't exclude them. Certainly they're familiar with the case. So how familiar can you be with the case before you're disqualified as having perhaps, in the lawyer's mind, you made a decision already?
Well, that's what the lawyer has to really dive into and make sure that you haven't made a decision already. So they need to know, what do you know about the case? What have you heard? How has that influenced you? Are you able to sit with an open mind? Many people will be able to sit there and say yes, but certainly there are questions you can ask that go beyond that. For example, were you related to anybody who was in the fire? Do you know anybody who was related to anybody in the fire? Have you ever been in a fire? Do you know anyone who's ever been in a fire? Things of that nature, where you might be able to get more information out of the person rather than just what do you know about it, or how do you know about it.
With a civil or criminal, do both sides get to choose as decide whether or not that juror is acceptable, and does it have to be a unanimous decision if one says yes, one says no? How does that work?
Right. So it is the same in some ways, civil or criminal, in that both lawyers get challenges. So you have preemptory challenges, which is a challenge not for cause. I just don't want that person on my jury. There's only a limited number, depending on the number of jurors that are going to sit in the pool, 6, like I said, or 8 for civil, 6 really that are sitting, 12, and then the 2 alternates in criminal. So the more jurors that sit, the more preemptory challenges, the challenges that you can just make because you're not comfortable with that person on your jury. Then, of course, there are challenges for cause, and that's why some of the more well-known cases that are coming to trial may take longer to sit a jury for, because you're going to have more opportunity to challenge for cause. The ability to challenge someone on bias is going to be greater, perhaps, in a case where there's a lot of notoriety and they express their bias in the voir dire process. And you have to be careful to make sure you're getting everything out, because sometimes a juror doesn't give you everything and they're trying to hold back. In fact, John Grisham wrote books about that, or a book at least, where someone's trying to get on a jury because of a bias that he really wants to exercise in that case. So it's not a real world kind of thing. You don't see that, I hope, or merely is fiction. But there are people who have biases that they might even know it's a bias in the case, but you need to be careful to go through and find out everything that might be a potential bias in a particular case.
Well, I want to talk about it a little bit more later. Let's look at the other side of that, David. Suppose someone clearly didn't want to serve on a case or at all. If you were asking them some questions and they didn't want to serve, it might be very easy for someone to say, I already know the answer to that, or something similar to that, perhaps not that blatant, but enough so that you would be inclined to say automatically that is not an acceptable or qualified juror, or I just would like to dismiss them. So my point is, someone could easily, if they didn't want to serve, say, not that he looks guilty, but yes, I've read quite a bit. I think that we have a lot in that case that says we might want to convict him or something.
Right.
So couldn't someone use that as an excuse, as a way to be dismissed?
Judges have a lot of experience in knowing when somebody is being truthful and just trying to get out of service. So if somebody is just overplaying their hand to get out of jury service, the judge may pull them aside and question them separate and apart from the rest of the jury pool to really get at what they're doing and let them know that we know, so what's really going on here and what do you really think? And It's possible that you can overplay your hand so much that you do get out of a case, but judges and lawyers recognize when that's happening and usually do have a fairly effective way of dealing with that.
Good to know. And with grand jury selection, does that have in any way a different set of standards? I know most people will talk about, well, grand juries can indict, quote unquote, the ham sandwich. So
Right.
very easy to have that happen. True?
So, well, yeah, this is because of the process, and so we'll talk a little bit about the difference between the grand jury and the
Yes.
trial jury. So the trial jury, as I said, is picked through this voir dire system, and then the challenges and the preemptory challenges, and then at the end of the day, both sides are supposed to hope that they've ended up with a fair and impartial jury, but of course each side is hoping that they've ended up with a jury that might be more partial to their side of the story. A grand jury doesn't sit for trials. A grand jury sits to sort of investigate and indict cases that are brought to them by the Attorney General in Rhode Island, the U.S. Attorney if it's a federal case, the District Attorney in Massachusetts. And the whole point of a grand jury is to serve somewhat as a sounding board, but as a body of citizens that's brought together to determine whether or not there is sufficient grounds for somebody to be charged with a crime. So let's think of an example. Well, any criminal case. A grand jury is brought in, and it's called a grand jury because it's a much larger body of people than the 6, 8, 12, or 14 that sit in the other cases. And they don't sit every day until a case is done. They sit when there's information to be brought. So it might be once a week, it might be twice a week. It depends on how active the grand jury is at the particular time and whether they're hearing multiple cases that are being presented to them. Sometimes a grand jury, I think Ken Starr had a grand jury just for that Monica Lewinsky and the investigation of the president to hear information and so forth. A grand jury can ask to hear witnesses, ask the prosecutor to bring witnesses in so they can hear those witnesses themselves. The hearings and anything that goes on in front of a grand jury is confidential and cannot be leaked by anybody. It's why people are expected to speak freely in front of a grand jury. Lawyers do not go with witnesses in front of the grand jury. The only lawyer, and this is where the I can indict a ham sandwich thing comes from with the grand jury, is the only lawyer in front of the grand jury is the prosecutor, the Attorney General, the U.S. Attorney, or whoever it happens to be. And so they can sort of shape what gets there. They can answer the questions the way they want to answer the questions, and they sort of control the process. But at the end of the day, the grand jury then either hands up an indictment, as they say, or declines to indict somebody.
So to be clear, neither the defendant and the defendant's lawyer never see that grand jury. Is that correct? At that time?
That's correct.
And if they don't, the jury does not hand out an indictment, what happens with that case?
So generally speaking, if the grand jury refuses to indict somebody, then the prosecutor usually won't bring the case. But there are other ways of bringing criminal cases. In Rhode Island, the Attorney General can charge somebody by information. So when you're charged by information, you have a right to a preliminary hearing, which is for a judge to decide whether there are reasonable grounds for the case to go forward. And it's short of, beyond reasonable doubt. It's just, is there a reasonable basis for the case to go forward? And so the judge will hear information presented. And these things are sometimes public, and you've seen these kinds of cases often. I believe, I'm not 100% sure, but I believe that the fellow who shot the kid in Florida was Trayvon Martin, was that the name of that case?
Yes, I believe so.
I believe that the lower court had a preliminary hearing that was aired on TV. And so that was where the evidence was presented by the prosecutor. The defense generally will not do a lot at a preliminary hearing because they don't want their defense to be put out at that early stage, but they'll take advantage of the requirement of the prosecutor to get past that hurdle of proving that there's enough of a case to go forward. And the prosecutor oftentimes may not want to present all of his or her evidence too, because they want time to develop it, but they have to present enough to get by that. So it's time for the defense attorney to get a little insight into what the witnesses will be like. And that's oftentimes why you won't waive your right to that preliminary hearing, so that you can get a flavor of the witnesses and get to see them and how they'll testify and all that, even though generally the burden isn't that high to move forward to the trial stage.
Hence the ham sandwich.
Right.
How long does it take for the jury pool to take place? On a given day, is it, or a given case, could it be a week of that selection process, going from the box, from the pool to the box?
We're back to the petite jury for the
Yes,
trial.
and then the other, then
Well, the
both.
grand jury, they get picked, they're selected, now they're sitting.
How long?
Well, they could sit a month, they could sit 2 months. It depends on what they're hearing and what type of case it is. But they don't sit every day. And there are some grand juries that sit for an extraordinary long amount of time, but again, it's not every day. The other case, the sitting of the jury to the end of the trial, you know how long the O.J. Simpson trial took. You know, that's an extraordinary long example, but most civil trials are probably somewhere between a few days and a few weeks, a month on the long side, not usually. Criminal trials the same for the most of them, but there are some that can take months.
And are jurors paid? How much are they paid? I understand that it varies.
Yeah.
And what about reimbursement of their parking, et cetera?
So there are, I think in Rhode Island now, we actually developed some shuttle system and some parking where you park and you don't pay for parking, and there is a minimal pay. But what we hope for is that good employers will continue to pay their employee a salary while they're doing their civil duties.
You hope. And if they are, does that help you decide whether or not, or how much you're going to be you as the court, or is there just
No,
a set fee anyway?
There's a set fee. I have never sat on a jury, so I don't know what it is.
No, you've been on the other side of
Yeah.
it, I guess. What about,
And it's not much, I know that.
yes, it's a
But they
pittance.
do get lunch while they're deliberating.
Good to know. For someone who is working, if their employer is likely to balk, is that a reason for them to be, if not dismissed, at least deferred?
You cannot fire someone because they are required to sit on a jury.
And if you are called and you know that your employer is not happy about it, maybe because they don't like the case or what might be a case or how long you might be gone, and they just give you a little grief, slight harassment, what happens and what can you do about it? Because apparently that's an issue for some people.
It can be an issue. I've never run into that, so I don't know if there's a process where the court would ever get involved in something like that. But certainly, if you're exercising your constitutional obligation and you are being harassed as a result with it, you could have a claim against your employer for doing that.
Okay. And the idea that a jury is now seated, what's the relationship? What happens next? What does the judge actually have to say to the jury before they begin a case?
After they've been sworn in?
Sworn in.
So the process of the trial at that point is the jury is seated. Both the plaintiff and the defendant, or the prosecutor and the defense counsel, have told the judge that they've agreed that the jury is acceptable to them. The judge swears the jury in, and then explains what the next role in the case is, which is usually opening statements.
And that you should be objective.
Yeah, well,
and
that's part of
open-minded.
that whole swearing in, is what their obligation is to keep an open mind. Jury instructions at the beginning of a trial, which aren't really jury instructions, generally would be not to talk to each other about the case while the case is going on. Don't begin deliberations until the case is rest. Don't talk to anyone else about the case. Don't have any interaction with the parties or the lawyers. If anyone approaches you, let me know. Don't read the newspapers or listen to any TV accounts of what's going on. All of those things are instructions that the judge gives to the jury at the beginning of the trial, and at every day when they take a break and every time they come back and all of those things, as opposed to jury instructions, which are instructions on the law of the case. And then, so what the role of the trial jury is to determine the facts. The judge instructs them on the law.
Okay, I don't know that we're going to have time to discuss jury nullification, but that will be perhaps another topic. But considering we're going to be talking about jurors today, what about the bona fide reasonable excuses that someone might have to not serve? What are some reasonable excuses for not serving?
And the jury commissioner is generally reasonable with people who have legitimate excuses. And what a legitimate excuse is going to do is buy you some time. So you'll be excused from service at that particular time, but you'll be expected to serve when your name gets called again, which will happen. So illness in a family. My daughter just had a baby. I would imagine having a newborn would be a reasonable, legitimate excuse. If you just started a job and are very concerned about that, you might be able to defer serving. Anything that would interfere with your ability to sit at that particular moment, that's a reasonable cause that would cause anybody to be unable to sit at that particular moment, that is going to pass. It's not a permanent thing. The jury commissioner will consider and probably give you a deferment.
What you describe, I suppose, is under the banner of it not supposed to be causing undue burden or financial hardship. Judge, I absolutely have to work and make my pay, or, I'm going to lose my house or whatever. I've been ill, I have an ill person at home, I have a newborn. I have a vacation already planned. What about that?
Well, if it's a paid for, expensive, already paid vacation, they would probably give you a deferment. You would come back and serve, but after you did your trip around the world.
And if you've already booked the airlines,
right.
you can't make...
Non-refundable.
That's right. And if someone says, I think I do want to serve, but I haven't been called yet, can I volunteer?
I don't know that you can volunteer, but you could certainly contact the jury commissioner and ask if there's a reason why you've never been called.
They do say, that's a good point. They do say that it's random, but might want to follow up on that.
Right.
It's supposed to be a wonderful experience serving on jury duty. We hope that some of this has been helpful to you and interesting to you. We hope that you will also stay tuned to the Law Matters. We'll be discussing perhaps the next time jury nullification, that there are quite a few very interesting cases that have taken place, and you mentioned OJ, so perhaps that might be one. And the current situation with marijuana laws also poses some very interesting issues and responses. We hope you'll stay tuned to the Law Matters, because the law matters to you.